Okay, we're studying criminal law right now and have progressed to the very end of the book. This is chapter 10, Third Parties, Rights and Responsibilities, the Assignments of Rights, which is section 3. And A is titled Assignability of Rights, Means of Assignment. An illustration in the restatement supposes that B contracts with A to furnish A's family with all the oil it shall need for the ensuing year at a fixed price. Illustration 3 to section 334 is referenced here from the restatement. The supposed contract suggests the question whether or not either party might transfer, in other words, assign, to someone else its rights. A to X, A's right to a supply of oil, or B to Y, B's right to payment. Take first an attempt by B to assign to Y its right of payment for oil supplied. In all probability that will succeed in the sense that A must pay Y for the oil that B delivers. It may succeed also in the case that A cannot satisfy her debt by paying B. But that depends on the circumstance of the payment, and as will be seen. B's attempt may fail in the sense that B retains the power to revoke the assignment, but that too depends on circumstances to be indicated. On turning to an attempt by A to assign X her right to a supply of oil, one must make a fundamental distinction. It is one thing to call it success if, should B fall short of supplying A's family with oil, it must pay damages to X. It is quite another to say that success is in assigning means that B must thereafter supply the needs of X family, rather than those of A's family. The restatement illustration mentioned above goes on to say that an assignment by A cannot confer on some other person a right that that person's family be supplied with oil. The restatement rule on this subject appears in section 317.2, cited in the opinion that follows. The section begins, in parentheses, a contractual right can be assigned unless, ... and paren. One of the restrictions stated there applies when, quotations, the substitution of a right of the assignee X for the right of the assignor A would materially change the duty of the obligor B. That restriction appears to apply, and end quotation, that restriction appears to apply unless the requirements of X's family are known to be nearly identical of those of A's family. A comparable case now dated is Crane Ice Cream Company versus Terminal Freezing and Heating Company concerning a sale of ice. Terminal Freezing had agreed to supply within limits the requirements of Frederick, attempted to assign his rights and to delegate his duties under the contract to a much smaller multi-state operator. Crane Ice Cream, according to the court, that attempt constituted a repudiation by Frederick of his contract with Terminal. By the way, we're now on page 926. Now that the code is in place, it would govern on the facts that of Crane Ice Cream and on the others supposed above, all of which concern sales of goods, which is under the Uniform Commercial Code, UCC, section 2-210, in paren 2. UCC, this section, was the pattern for the restatement rule quoted above. Subject to some stated exceptions, it provides that, quotations, all rights of either seller or buyer can be assigned, end quote. It is not so, however, quote, when the assignment would materially change the duty of the other party, end quote. Now we are presented with a problem to help demonstrate the concept. Ice lifting period. Disregard the problem of delegation in Crane Ice Cream and consider only the problem of assignment there in relation to UCC section 2-210-2. Does the code validate Frederick's assignment of his right to ice? Question. Does it matter that between its newly acquired Baltimore plant and one it already owned in Philadelphia to take account of differences between its ice costs at the 2 points? How likely would that adjustment be? Notes. So this is after the problem section. The notes, delegation and repudiation, period. The code does not track the statement about repudiation in Crane Ice Cream. What it says is that any assignment which delegates performance entitles the other party, B, in the illustrative case above, to demand adequate assurance of due performance from the assignee, X. In that case, it says also that the other party may treat the assignment as creating reasonable grounds for insecurity. End quote. Presumably that would entitle B to demand assurance from the assigning party. See UCC section 2-609. One's failure to make an adequate response to a justified demand accounts by that section, to a repudiation. In parentheses, it says that both entitlements are stated in subsection 6 of the UCC 2-210. It would seem sensible to say that B cannot require adequate assurances from both A and X, but must be content with an assurance from one or the other. But that is not what subsection 6 says. 2, on our notes, loss leverage is the title. Reading, Professional Richard Epstein has described a burden that an assignment may place on a promisor even though the assignment does not alter the prior legal position of the promisor. Quotations, the promisee is a known quantity chosen and selected by the promisor. Even if the legal system gives the promisor the same rights against the promisee's assignee, the value of those rights still may be reduced by the assignment. The promisor may not have any informal leverage against the assignee. Preventing the assignment reduces the cost to the promisor by fixing the content of the obligation that would otherwise run to an unidentified party. Wire strain alienation question is something references coming from A5 column L REV. Is any informal leverage, in quotes, against a chosen promisee lost if the promisee assigns only its rights and delegates none of its duties? We're at the bottom of page 926, and I'm about to start our case Herzog versus Irace from the Supreme Judicial Court of Maine in 1991. Brody is the justice, writing here that Anthony Irace and Donald Lowry appeal from an order entered by the Superior Court of Cumberland County, confirming a district court of Portland judgment in favor of Dr. John P. Herzog in an action for breach of an assignment to Dr. Herzog of personal injury settlement proceeds collected by Irace and Lowry, both attorneys, on behalf of their client, Gary G. Jones. On appeal, Irace and Lowry contend that the district court erred in finding that the assignment was valid and enforceable against them. They also argue that enforcement of the assignment interferes with their ethical obligations toward their client, finding no error, we affirm. The facts of this case are not disputed. Gary Jones was injured in a motorcycle accident and retained Irace and Lowry to represent him in personal injury action. Soon thereafter, Jones dislocated his shoulder twice in incidents unrelated to the motorcycle accident. Dr. Herzog examined Jones' shoulder and concluded that he needed surgery. At the time, however, Jones was unable to pay for the surgery, and in consideration for the performance of the surgery by the doctor, he signed a letter dated June 14th, 1988, written on Dr. Herzog's letterhead, stating, I, Gary Jones, request that payment be made directly from settlement of a claim currently pending for an unrelated incident to John Herzog, D.O., for treatment of a shoulder injury which occurred at a different time. Dr. Herzog notified Iris and Lowry that Jones had signed an assignment of benefits from the motorcycle personal injury action to cover the cost of the injury on his shoulder and was informed by an employee of Iris and Lowry that the assignment was sufficient to allow the firm to pay Dr. Herzog's bills at the conclusion of the case. Dr. Herzog performed the surgery and continued to treat Jones for approximately 1 year. In May of 1989, Jones received a $20,000 settlement in the motorcycle personal injury action. He instructed Iris and Lowry not to disburse any funds to Dr. Herzog, indicating that he would make the payments himself. Iris and Lowry informed Dr. Herzog that Jones had revoked his permission to have the bill paid by them directly and indicated that they would follow Jones's instructions. Iris and Lowry issued a check to Jones for $10,027 and dispersed the remaining funds to Jones' other creditors. Jones did not send a check to Dr. Herzog, but the check was returned by the bank for insufficient funds, and Dr. Herzog was never paid. Dr. Herzog filed a complaint in district court against Iris and Lowry, seeking to enforce the June 14, 1988 assignment of benefits. The matter was tried before the court on the basis of a joint stipulation of facts. The court entered judgment in favor of Dr. Herzog, finding that the June 14, 1988 letter constituted a valid assignment of the settlement proceeds enforceable against Iris and Lowry. Following an unsuccessful appeal to the Superior Court, Iris and Lowry appealed to this court. Because the Superior Court acted as an intermediate appellate court, we review the district court's decision directly. See Brown v. Corvio. We set aside trial court findings based solely upon documentary evidence and stipulated facts only if clearly erroneous. So, this is still part of the case. Validity and assignment is now examined as part of this case. An assignment is an act or manifestation by the owner of a right, the assigner, indicating his intent to transfer that right to another person, the assignee. See case law Shiro v. Drew. For an assignment to be valid and enforceable against the assigner's creditor, debtor, the obligor, in parens, the assigner must make clear his intent to relinquish the right to the assignee and must not retain any control over the right assigned or any power of revocation. The assignment takes effect through the actions of the assigner and assignee, and the obligor need not accept the assignment to render it valid. Looking at Palmer and Palmer, a precedent case in Maine, 1914. Once the obligor has notice of the assignment, the fund is, from that time forward, impressed with a trust. It is ... impounded in the obligor's hand, and must be held by him not for the original creditor, the assigner, but for the substituted creditor, the assignee. After receiving notice of the assignment, the obligor cannot lawfully pay the amount assigned either to the assigner or to his other creditors, and if the obligor does make such a payment, he does so at his peril, because the assignee may enforce his rights against the obligor directly. Ordinary rights, including future rights, are freely assignable unless the assignment would materially change the duty of the obligor materially increase the burden or risk imposed on the obligor by his contract, reduce the value of the return performance to the obligor, and unless the law restricts the assignability of the specific right involved. And that comes directly to us from the Restatement of Contracts, Section 317. In Maine, the transfer of a future rate of proceeds from pending litigation has been recognized as a valid and enforceable equitable assignment. An equitable assignment need not transfer the entire future right, but rather may be a partial assignment of that right. Looking to Palmer again, we reaffirm these well-established principles. Iris and Lowry contend that Jones's June 14th, 1988 letter is invalid and unenforceable as an assignment because it fails to manifest Jones' intent to permanently relinquish all control over the assigned funds and does nothing more than request payment from a specific fund. We disagree. Why? The June 14, 1988 letter gives no indication that Jones attempted to retain any control over the funds he assigned to Dr. Herzog. Taken in context, the use of the word request did not give the court reason to question Jones's intent to complete the assignment, and although no specific amount was stated, the parties do not dispute that the services provided by Dr. Herzog and the amounts that he charged for those services were reasonable and necessary to the treatment of the shoulder injury referred to in the June 14th letter. Given that Iris and Lowry do not dispute that they had ample notice of the assignment, the court's finding on the validity of the assignment is fully supported by the evidence and will not to be disturbed on appeal. So this was more or less express intent. The intent formed a trust. Ethical obligations is a next section. Next, Iris and Lowry contend that the assignment, if enforceable against them, would interfere with their ethical obligation to honor their client's instructions in dispersing funds. Again, we disagree. The Bar Rules of Maine require that an attorney promptly pay or deliver to the client as requested by the client the funds, securities, or other properties in the possession of the lawyer which the client is entitled to receive. The rules say nothing, however, about a client's power to assign his right to proceeds from a pending lawsuit to third parties. Interesting. Because the client has the power to assign his right to funds held by his attorney found in McClellan and Walker, which is a preceding case in Maine, it follows that a valid assignment must be honored by the attorney in dispersing the funds on the client's behalf. Iris and Lowry were under no ethical obligation, and the record gives no indication that they were under a contractual obligation to honor their client's instruction to disregard a valid assignment. The district court correctly concluded that the assignment is valid and enforceable against Iris and Lowry. Means of assignment is the last section of this case. Both the Uniform Commercial Code and the Restatement recognize that an intention to assign payment rights of some kind can be implemented by making a delivery. These are rights represented by what the Restatement calls a writing of a type customarily accepted as a symbol or as evidence of the right assigned. Coming to us from Restatement, Section 332. An instance is a passbook symbolizing a bank savings account. The code provides for comparable transfers of certain interests that are not payment rights. It provides also for implementing transfers of some payment rights and some other interests by establishing control in the transferee. These include transfers of deposit accounts generally. See UCC Section 9-203B as to both delivery and control. These modes of assignment are not addressed further in this book. What follows next is about language as a means of assignment. According to Section 324 of the Restatement, an intention to transfer a contract may be manifested except as provided by statute or by contract, either orally or by writing, but what language to use requires some discrimination. The language used by Gary Jones and Herzog is less dispositive than that customarily used by competent attorneys wishing to effect an assignment. Several other forms of expression are now to be illustrated. Some of them constitute assignments, others do not. Each of them should be compared with the language used by Jones. So we've actually concluded the case. So I'm going to pause here.